All rise. The Court of Appeals, Division 1 is now in session.
Be seated. Good morning, I think. Now is the time set for oral argument in cause number 1CA CV16 0500 and 1CA CV16 0559, those cases having been consolidated. This is Allstate Property and Casualty Insurance Company versus Watts and State Farm Fire and Casualty Insurance versus Watts. For everybody's information, the proceedings are being audio and video recorded, so absent technical failings, you should be able to take a look at these and review your argument or opposing counsel's argument in a few days. Counsel, each side will be entitled to their normal 20 minutes, the customary 20 minutes, and we would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. And for the appellant's purposes, I want to advise that if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will try not to take all your time up otherwise. However, ultimately, it is your responsibility to preserve that time. We've reviewed the briefs and conferenced the case this morning. We are well aware of the facts and issues attendant to this argument. As I always say, we say that so that you can decide based upon that how you want to fashion your argument today. Counsel, when you come to the podium, I would ask that each state your name and who you represent. And with that, it is the appellant's podium.
Good morning, Adam Polson on behalf of Watts Regulator, Watts Water Technologies. I'd like to reserve 5 minutes for rebuttal. As a brief state, the laws favor arbitration agreements as a matter of public policy. This is very clear in Arizona law, where doubts regarding arbitration agreements are resolved in favor of arbitration. This is also.
But we do adhere to the concept, don't we, that the court will decide what's arbitrable? That's
correct. And in this case, the terms of these matters are arbitrable, and that's because Article 1st says that the parties must forego arbitration.
Yes. Article 1st outlines, in the arbitration agreement, outlines what is arbitrable, and Article 2nd, I guess it is, or whichever one has the exclusion, says what isn't.
It does. Article 2nd, in effect at the time of these losses, which were both in 2014, did not exclude property cases. Effective January 1 of 15, which is in between what happened here, then arbitration forums then decided to make it optional to go to arbitration forums for property subrogation cases.
We have the pattern.
Did they have the letter? I'm sorry.
No, I was just going to say, we have that sequence of events in mind.
Right. Did they have the power to do that, counsel? And did they do it consistent with the power they may or may not have had?
Article 5th provides some certain powers. Article 5th provides some powers to make rules and regulations regarding how these arbitration proceedings are conducted.
Was this a mere rule and regulation to say, well, product liability, property damage claims will no longer be mandatorily arbitrable?
No, this is in effect canceling the prior agreement. I would say that if we change rules of evidence or something of that nature, witnesses have to appear live. Evidence is presented based only on papers. That's a rule that Article 5th contemplates. But changing the entire scope of this agreement is another animal.
When Watts employed or entered into the agreement using AF, what was the scope of arbitration that they believed themselves to be subject to? Is that a question you understand? Have I asked that well enough?
Yes. So in Allstate joined in 1986, State Farm in 2003, Watts in 05. And so this agreement has been in existence for a fair amount of time. And at the time that Watts entered in 05, the understanding to everyone was that everything under $100,000 was mandatory.
Is it in regard to contract breaches and tort claims, or is it just products liability stuff?
This, if you look at the actual agreement, the top of it says property subrogation. There's other agreements maybe for motor vehicle accidents or other things, but this is related to property subrogation cases. And so in this case, Watts manufactures water products. You may have something in your home, and it's really a subrogation case where an insurance company like Allstate or State Farm pays out and decides that the product is defective, and they want to try and recoup what they paid out. So at the time of these losses, everyone was signatories to this agreement. Article 1st provides that the parties must forego arbitration. If the appellees filed their claims during this time frame, there's no question that they would have to pursue arbitration through arbitration forums. They decided not to. They held on to these claims until basically the eve of statute of limitations, and at that time arbitration forums was no longer mandatory. So obviously the issue is whether rights that accrued will exist past the new change of the agreement.
What rights had accrued?
Watts had a right to arbitrate these claims. That was the scope of.
Would Watts have had a right to arbitrate these claims if there weren't signatory insurance companies involved?
No.
No. So how had that accrued by January 1, 2015?
Well, they actually accrued, I would say, on the date of the loss, which were both in the spring of 2014.
Well, I know that when, general subrogation law, when an insurer pays a claim and is subrogated to the insured's claim, we go back to the date of loss for probably several purposes, a common one being, for example, the statute of limitations. But why do we do it here?
I think you have to do it here because of Article 1st that says that parties must forego arbitration, or must forego litigation and proceed to arbitration. And it doesn't make any sense to let insurance companies sit on their hands and wait till the agreement expires and then allow them to proceed in litigation. Watts doesn't have the right to file any of these claims because Watts is never going to be seeking damages.
Counsel, were the insurance companies put on notice at the time of the incident that this was a hanging claim out there that they were ultimately going to be responsible for?
I think that's a question for the insurance companies to ask as to what investigation that takes place. But in my experience, yes, they know right away that this is a damaged product, or within a matter of weeks that they think that this product was damaged, as opposed to maybe homeowner negligence or some other reason as to why they would want to subrogate this case.
They wouldn't have been caught by surprise a year later when the rules change and then they find out that the product's liability, under your theory, that the product's liability provisions of the arbitration agreements were their baby, were their problem.
That's correct. These insurance companies are very sophisticated. They've got claims departments. They've got national counsel. You see a bunch of them here. And they, for whatever reason, decide when and how to file their claims. But I think it's pretty clear that within a matter of days or weeks after this claim, they knew that they were going to subrogate these cases. And they just decided to hold off on that for whatever reason.
So back to my question then, the right that you're asserting to us that was accrued is a right to arbitration.
Of course.
And are you claiming that was a vested right before the arbitration agreement changed on January 1, 15?
Yes, that's entirely correct. So at that point, Watts had. And of course, no one knew that the arbitration forum rules were going to change. But in that
you knew by November, December.
Right. But in that 6-week or 8-week period, the insurance companies decided not to do anything either. They could have submitted claims, and that those would have been subject to arbitration. They chose not to do that either. Watts was unable to do anything, and Watts tried to do something, but they couldn't do anything because they can't initiate these arbitration provisions.
We're dealing here with contract law. Do you agree?
Yes.
Is there anything about what went on in November or December of 2014 that impacts the contract law analysis?
Well, I think that the Article 1st still stands on its own. The bulletin that came out, I don't think that it's evidence, because I think Article 1st is clear and unambiguous. And there are certainly problems with the bulletin that came out. It is very unclear as to...
You're talking about the e-bulletin?
Yes, Your Honor. November 4th.
AF is stating what it thinks.
Right. November 4th, 2014. It's not clear at all as to what happens. All it says is that there's going to be a rule change, and that that anything that happens after January 1, 2015 is not mandatory. It does not address a loss that took place in spring of 2014, for example, as to whether that's subject to arbitration or not.
Would you, if the e-bulletin language that focuses on date of filing had been included into the amended arbitration agreement that was effective on January 1, 2015, if it had been stated in conjunction somehow with the new exclusion, would you then agree that arbitration forum had the power to change that contract?
I would not agree with that, Your Honor, and the reason is because this is a vested right, and perhaps arbitration forums had the right to change rules regarding evidence or other matters to streamline, but this is such an important right to the contract that I don't think it can be taken away retroactively.
What,
Counsel, go ahead.
What makes it vested when no lawsuit has been filed yet?
It becomes vested because the loss took place and both parties were signatories to this agreement. Watts can't do anything.
Not the homeowners.
That's correct, but the homeowners are not.
Insurers and Watts in our consolidated case here.
Right. If I had a loss and if I paid money out of my own pocket, I'm not part of that agreement. I agree with that. And not every insurance company is necessarily part of arbitration forums, but many insurance carriers decided it would be more efficient, and this is why we want to do it. We don't want to do litigation. We want to do a streamlined process for claims under $100,000.
Understood.
So you're saying it's the fact of the loss in the context of you being signatories, you and the insurance companies being signatories to the AF arrangement that makes it vested.
Yes.
It's not the simple agreement.
It's correct. If the loss took place on March of 16, we're not going to arbitration unless the appellees consent to that.
In other words, you more or less have an agreement even preceding the loss, do you not? You have an agreement to arbitrate certain things in the event of a loss.
Yes.
But you're saying that somehow it's not vested until there's actually the loss.
Well, there's nothing to litigate until there's
Right,
a
but
loss.
you couldn't argue about AF changing the definitions of what's arbitrable if you'd never had a loss, if there'd never been a loss.
If I understand your question, hypothetically, if
I'm just saying, most people, you have a contract, I agree, both parties agree that if something happens, this is how we will handle it. That sounds like a contract, but you're suggesting that it's not really a vested the rights don't vest to arbitration unless and until there's a loss.
the contract's in effect, but there's nothing to arbitrate until there is a loss, is how I would explain it to you. You know, if I have a Watts product in my house and there's nothing that takes place, there's nothing to litigate.
Well, I mean, I'm just trying to understand how the contract would be modified unilaterally by a pronouncement from AF. I'm guessing you and the insurance companies are seen to have a contract. No losses occur. AF comes and says, we're going to change going forward what's arbitrable, and if nobody withdraws, then I guess you're all bound by the new provision.
In a sense, yes, but the problem here is that there are losses, and so you have to take that into account as to what's taken place. And obviously, going forward, arbitration forums has the right to change these rules. and create a new agreement thereby. But prospectively, so anything that happened on January 2nd of 2015, there's no question that that is not required to be arbitrated. But anything that took place December 31 of 14 and prior is subject to arbitration on arbitration forum rules.
So counsel, there's no specific period of time during which AF is bound to provide certain services under the agreement that's reached? It's not a 4-year contract for arbitration services or something like that?
No, it's not. And in fact, as I indicated, Allstate became a member in 1996, State Farm in 2003, Watts in 2005. So we've had this agreement in place for 20 years or more, at least between some of these parties.
All right, thank you.
Real briefly, I think we've covered most of this, but I want to just talk a little bit about some of the policy issues here and then reserve the rest of my time for rebuttal.
Well, before you get to that, am I correct in discerning that the whole issue here turns on whether AF could change the contract either with its e-bulletin or with its amendment in January of 2015 as to a loss that's already occurred?
AF, I think in a sense, let me reframe it a little bit. AF has the position, the ability to change things moving forward, but not retrospectively. And where there's
by retrospectively, you mean with regard to a loss that's already occurred?
Correct. There's just, it doesn't make
Everything in the contract, counsel, are we approaching that strata that might be referred to as an illusory agreement?
It is a illusory agreement because for starters, Allstate and State Farm have all the power to act. They can choose to sit on a claim. They can choose to file the claim. And looking at this in hindsight's always 20/20, but Watts wasn't able to do anything. And these rules did not address, when Watts became a member in 2005, there's nothing in these rules that said that had there been a rule change to this effect, what would happen to retrospective claims. But Watts had no power to do anything in this instance. State Farm and Allstate, they could have filed everything they wanted in 2014. Between the time that bulletin was announced and the time of the rule change, they chose not to do any of that.
But Watts still likes the deal. They haven't withdrawn.
Well, neither has either party has withdrawn, and everyone is still a party to this. It just doesn't have any teeth because no one's forced to do any arbitration. But if Watts had chosen to withdraw, that the problem is why it's illusory, is that State Farm and Allstate could have submitted all these claims within 60 days. There's a 60-day provision in Article 5th. So if Watts chooses to withdraw, State Farm and Allstate can file all these claims. But conversely, if State Farm and Allstate choose to withdraw, Watts can't do anything. I'd like to reserve the rest of my time for rebuttal unless you have any.
Thank you, counsel.
Thank you.
I understand that the appellees have agreed on a method to divide their 20 minutes. Is that correct? That's correct. Thank you.
Yes, Your Honor. Jonathan Tofflon for the appellee State Farm. I was going to take the first 15 minutes, counsel for Allstate the last 5. There have been numerous appellate court decisions on this, and so I think the Montero case in Illinois sort of lays out State Farm's position perfectly. The opinion, it's a published opinion in Illinois. We cited it in our brief, and so I don't want to, beat all those issues, but every specific issue, every case that is at issue now was decided and expounded upon in that opinion and explained. So
one of the things that bothers me about the Montero opinion is it seems to treat the e-bulletin language as though it was part of an agreement, when it looks to me rather clearly that it is not.
Yes, Your Honor. So that comes up to the thing of extrinsic evidence in the Four Corners rule in the contract, what's part of the contract and what's not. In this agreement, it expressly incorporates all of the rules of ARB forums. ARB forums has the power to make any rule or regulation that it sees fit. So it is actually incorporated into the agreement itself.
Are you saying the e-bulletin is a rule or regulation?
Absolutely, Your Honor. Yes, I do, because it explains how this amendment is going to be instituted.
We have in our record a copy of the rules and regulations. I don't think the e-bulletin language is in it.
Yes, Your Honor, they do have a formal packet that is described as rules, but they do make other rules, Your Honor.
Well,
and
and actually, the authorization is not just rules and regulations, it's qualified. Make appropriate rules and regulations for the presentation and determination of controversies under this agreement. I mean, one way to read that is just the rules for how to conduct arbitrations.
Well, yes, Your Honor, you could read it that way, but this has actually been litigated. So
Give us an Arizona case. You keep saying it's been litigated. Give us an Arizona case.
well, Your Honor, I think that it's been litigated.
This doesn't really look like a rule to me. This looks like a newsletter. We've got some pumpkins and a nice fall picture.
But they're nice pumpkins.
You're saying this is a formal rule or regulation?
Well, yes, it is a formal explanation, notice to all members describing how this amendment is going to take place and what they can and cannot do.
It certainly is a statement of AF's thought process and intent.
Yes, Your Honor.
What about the signatories?
Well, the signatories have vested AF with the right to make those types of rules.
Okay, so procedural rules, substantive rules, what we're going to do, what we're not going to do is solely within the purview of AF and even retroactively in this case. So they can, after the fact, determine that they don't want to handle a case that they previously agreed to handle. How is that not purely illusory?
Well, Your Honor, it's only retroactively if you believe that there's a vested or accrued right. And there,
Agree that the circumstance giving rise to the damages occurred prior to the e-bullet going out?
the circumstances, yes, Your Honor. You're dealing with an insurance company who doesn't even have a claim until they pay out on it.
I understand subrogation.
Okay.
But you're telling me that they can, after this thing has arisen, so they don't even have to say, look, we had an agreement, we agree that at the time this arose, that we were obligated to arbitrate for you this products liability issue, so we're going to stand by that. The answer is no. If the incident occurred and we look at it and say, ooh, that's kind of ugly, we really don't want to involve ourselves in one of those anymore, you can say, okay, retroactively we're not going to decide that. Is that correct?
It's not. This rule change came out in November, and it was not effective until January 1st, 2015. It was prospective in its application. They notified everyone about what was going to happen. It's only retroactive if you say that there is somehow a vested or accrued right. Now, under contract law, the contract has to be clear. It has to expressly, a vested right, and counsel.
They can amend that contract solely at their discretion.
They can amend the contract, and Watts actually sued Arbitration Forum, saying that they could not. That was the District of Massachusetts, a federal court in Massachusetts. Watts sued Arb Forums after this amendment, saying you do not have the power to do this. The District Court of Massachusetts dismissed that claim and expressly ruled that Arbitration Forums did have the power to do this.
Did that go up to an appellate court?
It was not appealed, Your Honor, and it is res judicata against Watts. Now, the issue this was not, the reason why this is not briefed is because that was not brought up by Watts. They did not argue.
Now,
It has been now, but they're saying at oral argument, so they brought it up now at oral argument, so I will bring it up again at oral argument. This is res judicata against Watts. They cannot now say that Arbitration Forums does not have the power when they've sued Arbitration Forums and lost. On that exact issue, we've given you the opinion from the federal court in our appendix. This was the District of Massachusetts. The case is Watts Regulator versus Arbitration Forums. So, and counsel didn't expressly say that because they don't want to bring up the issue of res judicata. They do this in all the cases around the country that I'm working on. They are not expressly saying Arbitration Forums does not have the power, because they know that we will then be able to make the res judicata argument.
Well, I mean, I can certainly see that AF has the power to say those things, but did that rule that AF has the authority to change a contract between insurance companies and Watts?
Well, and that's another unique thing about Arb Forums. Arb Forums is a membership. Some courts describe it as a club. the agreement that State Farm signed in 2003 is different than the agreement that Watts signed in 2005. They change their membership agreement ever so often. There is no actual contract between State Farm and Watts. There's nothing signed by them. They've signed versions, different versions of the membership agreement, which changes over the years.
How could anybody ever get anybody into arbitration? You have to have an agreement to arbitrate. So the agreement must be construed in some way, but it's between the insurance company and Watts in this case. I mean, it has to be construed as a contract. You'd have no agreement to arbitrate.
Yes, Your Honor. It is construed as a contract, but it's not the way, it's not like we separately decided. Every member is dependent on our forums it's like a country club, and they are the managing the association. And so their rules, their agreement, a membership agreement, which changes, is controlling at that time. That works because there are no vested or accrued rights until a claim is filed. Once a claim is filed, then any rule change, any amendment does not affect that claim. That's the reason why this all works, and that's why they've designed their agreement the way that they have. In Article 2, sub F, they talk about, stepping back, the way that we could figure out how a claim is accrued or how a right is accrued under the contract, or what the parties expected, because contracts are all about expectation, interest, and fulfilling the party's expectation. The ARB Forms Agreement tells us expressly what to expect. In Article 2, sub F, and Article 6, both of these cases deal with what happens when a member joins ARB Forms and what happens when they leave. When they join ARB Forms, any claim, the language is any claim which a lawsuit was instituted prior to and is pending at the time the agreement is signed is excluded. So that means that if it was pending prior to them being a member, the date of loss is prior to them being a member. But they're specifically saying that those claims are excluded, which means that the date of loss could not be controlling. It has to be the date of filing, because they're specifically excluding claims that are already pending in litigation before that person becomes a member. And that's what the Montero.
Coming back to this agreement to arbitrate, and Judge Jones has reflected his concern about illusory contracts. It seems to me that you could not construe AF's authority such as to change the treatment of a loss that's already occurred, because that would be the same as saying the insurance companies and Watts have agreed that if a loss occurs in the future, we agree to arbitrate whatever it is that AF decides is arbitrable. And that sounds like no contract at all to me.
Well, they still have a contract because they can arbitrate everything that ARB Forms says is arbitrable. You don't know what that is in the future. How's that a contract?
Or you don't know that a week from now it's not going to change something that happened a year ago.
Well, that is the very nature of the agreement. This is a nationwide agreement for massive companies.
Doesn't mean it's not illusory, though, counsel.
But if you're talking about the date of filing, Watts has the exact same rights as State Farm or Allstate. They can file claims in ARB Forms as well at any time, and then they could disassociate, they could leave ARB Forms, and they could file any claim in litigation that occurred at any time, according to Article 6.
So opposing counsel is correct when he says that the insurance companies can stall this back and wait for a change to occur and get out of the requirement to arbitrate while they can require the other party to arbitrate. There's a requirement to arbitrate against Watts in this case, but there's not a requirement to arbitrate against the insurance companies as long as they don't take on the subrogation responsibilities before a change is made.
Well, they don't know that a change is going to be made, just like Watts doesn't know that a change is going to be made. All the parties had 54 days notice of this. That's it. Watts can file, any member can file against another member. Okay? So Watts can get its suppliers and its manufacturers, instead of going into litigation with them overseas, those manufacturers can join ARB Forms, and Watts has the same power to file arbitration against any member.
So you're saying that Watts can require the insurance companies who are not yet subrogated on these claims to go into arbitration, right? They have standing to do that. On what theory?
No, not an insurance company. I'm saying that Watts, through a theory of if they are, let's say that they are a supplier and they have a manufacturer that defectively manufactured it, they can have tort claims or indemnity claims. They can have a number of claims against other parties, just like any other member. There's all types of, there's not just insurance companies, manufacturers. Anyone can become a member of Art Forms. Any company can be a member of Art Forms. Everyone has the same right. You can file against another member. Now, can Watts file a subrogation claim against State Farm? Well, no, not in that specific case, because they don't have any damages.
They haven't taken on the liability, right? The insurance company has not yet taken on the debt, the damage.
Well, it depends on the specific
In this case. We're talking about this case. They couldn't require your folks to arbitrate because the insurance companies had not taken on the damages from the incident.
Well, even then, they can't sue if they have no, Watts would have no damages, so they can't sue a subrogated carrier for a loss.
Okay, there you go. So it's back on the insurance companies.
What is back on the insurance?
The ability to utilize the arbitration requirement.
I think he's saying it's too unilateral.
Well, it is unilateral for every single member, though. Every member has that same right. Every member can file against another member if they have a claim.
Except for Watts.
Watts can have any type of claim against any other member that State Farm can. The fact of the matter is that State Farm has a lot of subrogation claims, so recognize that.
Watts is generally going to be, if not always, a defendant. So how are they going to file their claim?
Well, they still have the right to do so if they wanted to. If they had any claim against another member.
They had a claim.
If they had a claim, they could file it. It's completely reciprocal. It's not unilateral for any party. Every party has the same rights under the agreement. Whether or not in practice their business, gives them claims against other members, that's a different question. But it's not a question as to whether or not there's consideration or whether or not it's a illusory agreement. They have the same power as everyone else. They don't have to join this arbitration forms agreement, and it's completely voluntary. They have all the same powers as everyone else. Let's see here. I just wanted to touch briefly regarding the judicial estoppel argument. Well, in stepping back one more time, I just want to, on page 10 of Watts' reply brief, they say Watts does not argue that State Farm must arbitrate claims accruing after the 2015 amendment. And I think counsel said the same thing today. That is stating that it was effective, that it was a modification.
Well, I think they're saying it's effective as to contracts that are purely executory and nothing's ever happened. There's never been a loss on it. That's what I was inquiring about. Is they claiming that they have a contract, an agreement to arbitrate certain things, and that can never change, and it's not his position. His position is it's the fact of the loss that vested his right, or Watts's right, to arbitrate this claim. So I think that's what he means by that, I assume.
Well, if it was modified, it was modified. Okay, so the modified agreement, it takes precedence over a prior agreement, unless there is any sort of rationale for vesting. And I'm at under 5 minutes, so if Your Honor didn't have any further questions.
Thank you.
Okay, thank you, Your Honor.
Morning, Your Honors. I'll just touch briefly on just one or 2 points here. I won't repeat anything. One point I just wanted to issue is, the appellant tries to emphasize the fact that the insurance companies have a unilateral right to do whatever they want and to hold on to cases until whenever they want to. But the fact of the matter is we're still required to apply by the statute of limitations. The statute of limitations is the defense in arbitration forms. So we have 2 years to file our complaint, whether it's in arbitration forms or in litigation. So the fact we're not sitting back waiting, it's when we decide to file it within the statute of limitations.
Well, counsel, isn't it in fact when you make your claim and you take on the damages, when you are then a damaged party? Isn't that the case?
We are a damaged party. As soon as we make payments, we are subrogated to the rights of the insured. We become a damaged party.
Point precisely. So the filing isn't as significant as when you become the subrogated party, right?
Well, I disagree with that, Your Honor, because the filing is the key point in this thing, and it's even in the first article here of the property
So flip it
subrogation.
around for me, counsel. Then would you go ahead and require the arbitration before you had subrogated? Before you became subrogated?
We wouldn't be able to.
That's my point.
Right.
Go ahead.
Okay. So the Article 1st of the arbitration agreement basically requires signatory companies to forego litigation and submit their claims. Submit is the key word. You've got to submit a claim. You've got to file it. And that's when these, quote, vested rights that the appellant argues kicks in.
You're, just so we're clear, you're saying nothing is vested until a claim is submitted.
Absolutely.
What's magic about that?
That's the way the agreement is written. It's when you submit your claim. It's when you file the claim. There's nothing in this agreement that talks about when a date of loss came or when a potential claim arose. And, you know, even when a date of loss arises, most companies don't know that they have a claim that they're going to file until experts get involved, take a look at the product, determine if there's a claim to make payments, et cetera. So it's not the date of loss.
So the word submit that you're focusing on is in Article 1st?
Article 1st, Your Honor.
Okay. I see it.
And also the fact that statute of limitations is a defense in arbitration forms, which is the same if you were in litigation. So we have 2 years to file and submit our claim.
You might have less than that if the insured homeowner didn't tell you about it for a few months.
Well, whenever we find out when the date of loss is, that's when the date of loss is, and that's when the 2 years starts. So that's when we have to file our claim.
All of the rights go back to the date of loss for
statute of limitations purposes.
Limitations purposes.
Correct. And so those two key points that I want to make, Your Honor. I don't have anything else to make.
Thank you, counsel.
Thank you.
Your Honors, I just want to make a few quick points.
As you start, and before you get to your points, maybe this is one of them, would you comment on the Massachusetts case and why it is or is not res judicata against Watts?
It's not res judicata against Watts. What it held, as I recall it, was that there's no contract between Watts and arbitration forums, and
it says a bunch of things. I have what I think is that case here, and it does say, as AF is not a contractual party to the agreement, the complaint will be dismissed. And then it later says, nor because a party cannot breach a contract to which it is not bound can Watts show any consequential damages. So that appears to be certainly a significant part of the reasoning, and that's not an issue here. Although it does also say, which maybe swings a little more back in the favor of the insurers here, it says that the signatory companies implicitly recognize the authority of AF to define the scope of the arbitration services it will offer. So.
Yeah, and it says that at the beginning, it says that insurers and self-insured parties like Watts bind themselves to forego litigation and engage in arbitration. It also says that at most, AF is a third-party beneficiary, and the contract is between the parties, Watts and State Farm, Allstate, or any other signatory parties. And it says that because the AF can't breach the contract to which it's not bound, that's why the case was dismissed.
Well, it's of interest to me because I'm not convinced yet whether the language in Article 5th, I think it is, in the older versions, the older version that Allstate signed in '96, it was Article 3rd, but I think it's Article 5th now, which I view as key language, that arbitration forums can make appropriate rules and regulations for the presentation and determination of controversies under this agreement. I'm not convinced that that gives them the right to change what's arbitrable for events that have already occurred. And so that's, you know, are you conceding that it does?
Article 5th says regarding presentation and determination of controversies. It doesn't say anything about retroactive. It doesn't say anything about accrued rights. It doesn't say anything about when, you know, the loss date or anything of that nature. And looking at the case law, accrued rights are they take place when facts and occurrences arise. In this case, The facts and occurrences arise in both of these incidents in spring of 2014. And at that point, Watts had accrued rights. Whether or not State Farm or Allstate decided to file claims that day, it's immaterial.
You know, when we changed from, when our legislature enacted comparative negligence, which changed our contributory negligence system, our Supreme Court said rights are vested when a lawsuit is filed. A defendant then has a vested right in contributory negligence rather than comparative. Now, I realize that it's one thing when we're talking about what the legislature can or cannot do constitutionally, but in terms of defining vested rights, they said these aren't vested until the lawsuit's filed. Now, why is this contractual matter different?
ARS 1244 says that no statute's retroactive unless it's specifically stated. And in this case, arbitration forms does not say anything about about changing rules and what's retroactive.
It's not a statute anyway. Excuse me for interrupting.
That's correct, but the case law provides that nothing that rights are accrued when facts and occurrences occur, and that's uncontroverted, and that's what exactly happened here.
Law provides that. Say that again.
Nolde and Litton cases say that rights are accrued when the facts and occurrences that arise take place. And I'm out of time.
Thank you, counsel.
Thank you.
All right. Well, counsel, thank you for being responsive to our questioning. It has been helpful. We will take the matter under advisement at this time, and we will rule in due course. Thank you. I wasn't ready.